the court now proceeds with judgment in this matter of the state of Tiffany Meek versus the state. The charges against the applicant from the outset, the state submitted that this is a Schedule 5 bail application. The applicant stands arraigned on the following charges at count 1, murder led with the provisions of section 51(1) of the Criminal Law Amendment Act 105 of 1997 as amended, at count 2, defeating or obstructing the administration of justice, at count 3, criminal injuria, at count 4, attempting to defeat or obstruct the course of justice. The legal basis for the application. This application is subject, notwithstanding any provision of this act, when accused is charged with an offence referred to subsection B in Schedule 5, that the court shall order that the accused be detained in custody until she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduce evidence which satisfy the court that the interest of justice permits her release from detention. Onus and constitutional considerations. The wording of section 60(11)(b) makes it clear that an applicant bears the onus to satisfy the court on the balance of probabilities that the interest of justice do not require his or her detention. While the applicant bears the onus, the state is not entitled to adopt a passive role by not adducing any or sufficient rebutting evidence in the hope that the appellant might not discharge the onus. It is, however, to be borne in mind that any court seized with the problem of whether or not to release a detainee on bail must approach the matter from the perspective that freedom is a precious right protected by the Constitution. Such freedom should only be lawfully curtailed if the interest of justice so require. Section 35(1)(f) itself places a limitation on the rights of liberty, dignity and freedom of movement of any individual. In making the evaluation, the arrestee do not have a totally untrammeled right to be set free. Nature of bail proceedings. A bail application is not a trial. The prosecution is not required to close every loophole at this stage of the proceedings. However, a factor favoring bail is whether the applicant has established a defense which has a reasonable prospect of success at the trial. It must be pointed out that although a bail application is less formal than a trial, it remains a formal court process that is essentially adversarial in nature. A court is afforded greater inquisitorial powers in such an inquiry to ensure that all material factors are investigated and established. Evidence presented. In discharging this onus, the applicant, through her legal representative, deposed to an affidavit in adducing evidence before this court to satisfy this court that the interest of justice permits her release from detention. This application is zealously opposed by the state, who presented their case by the viva voce evidence of Sergeant Neighbor Protector Deco, who is stationed at the Florida Detective Branch. For the sake of brevity and to avoid unnecessary prolix, the court does not intend to deal with every detail of the affidavit, save for some apposite aspects that warrants reprise. Likewise, in the state's case, only pertinent aspects will be canvassed. The applicant sets out the background leading up to her arrest as follows. A. Jayden is normally dropped off from school by school transport between 3 and 4 p.m. on the 13th of May 2025. He failed to return home by 4 p.m., which was the time I stopped working. B. At that time, I was chatting to my mother and informed her of his non-return, and due to me not having airtime, I asked her to contact the transport owner and driver to ascertain if Jayden-Lee was dropped off or if there was an accident or delay. C. My mother contacted the transporter, and a while later she was informed that Jayden was dropped off around 14:45. I started to panic and look for him around the complex. D. It was getting closer to 5 p.m. and he had still not returned and could not be seen in the common area. I then approached the day shift guard, and he informed me that he could not recall if Jayden entered the complex. E. The night shift guard who lives on the premises confirmed that he saw Jayden enter the complex and did not exit. We also confirmed with the child who was dropped off after Jayden, and he confirmed that Jayden entered the complex. G. My mother sent her friend to collect me around 7 p.m. with a motor vehicle, and we all went to Florida SABC to report Jayden as missing. I was asked to complete a missing persons report, but it could not be lodged as the police needed to wait 24 to 48 hours, and they also wanted a printed copy of his photograph before opening a docket. H. 2 police officers came back to Swazi Place with us, but refused to go door to door and search for Jayden. We met 4 other officers on the way, and a total of 6 officers came back with us to Swazi Place. They first told us that it was too late to disturb the neighbors, and it was around 2100 hours, and thereafter told us that they don't have a search warrant. My brother, Ewan Dunn, then went to a few units and knocked on their doors, but was threatened with arrest and had to stop. J. On the 14th of May 2025 at approximately 6:50, I received a call from Lerato, the transporter, who informed me that Jayden had been found at Swazi Place. My sister Simone and her husband took us over immediately. K. It should be noted that Jayden was found around 6 a.m., yet we were only contacted approximately 6:50. No one bothered to call the ambulance or police or even rush my child to hospital, as it could have still been alive prior to our arrival. L. We took Jayden to Discovery Hospital in our vehicle, but he was pronounced dead on arrival. My son could have still been alive if he was taken immediately for medical attention or if an ambulance had responded. Applicant also sets out an approximate timeline of the police's handling of the matter and the events leading up to her arrest. These aspects will be addressed later in this judgment where necessary. The personal circumstances of the applicant is that she's married but separated from her husband. Jayden is the second child born to her, the first having passed away 2 days after birth. She was the sole breadwinner for her son Jayden, and she earned a monthly income in the amount of plus minus 17,500 rands, which money is utilized to support the family financially. She has an alternative address at Verulam, Durban, with her biological father. Applicant states that her family will suffer emotionally, financially, and mentally if she's not released. Applicant is still in shock, coming to terms with these allegations and charges leveled against her, as she has been the person asking for proper investigations into the death of her child, and verily believes that the police have failed in its duties to properly investigate the matter. Applicant submits that the personal circumstances herein illustrates that A. If released on bail, she would not endanger the safety of the public as envisaged by section 60, bracket 4A. B. There is no likelihood that she would attempt to evade her trial as envisaged by section 60, bracket 4B. C. There is no likelihood that she will attempt to influence or intimidate witnesses as envisaged by section 60, bracket 4C. D. There is no likelihood that if released she will undermine or jeopardize the objectives of the proper functioning of the criminal justice system as envisaged by section 60, bracket 4D. E. there is no likelihood that her release will disturb the public order or undermine the public peace, security, and safety as envisaged by Section 60, bracket 4E, read with Section 60, bracket 8, capital A. Other factors to be considered: 1, that the applicant is a first offender; 2, there are no pending charges against her; 3, she's not on parole in respect of any charges, neither is there any interdicts for domestic violence or harassment against her; 4, after all the arrests and interrogations, applicant continued to live with her mother and never attempted to flee from the police. Neither did she resist the arrest. 5, applicant respectfully submits that she has discharged the onus of proving to this court that it is in the interest of justice that she be released on bail. In rebuttal of the aforementioned, Sergeant Deco, hereinafter referred to as Deco, under oath sets out the sequence of events from the time the child is reported missing to the arrest of the applicant as follows. A. Deco confirms that indeed a missing persons report was filed on the 13th of May around 8 o'clock under Florida Cas 25/2025. The applicant made a statement as per Exhibit B, whereafter she was escorted by the police back to Swazi Place. Before leaving, applicant, as per her statement, contacted Mr. Kamalo, who informed her that he left her son Jayden-Lee at the gate of Swazi Place at 14:55 and proceeded to give a description of the clothing worn by Jayden on that day. B. Despite the aforesaid, the police, in the company of the applicant and family, stopped at the residence of Mr. Kamalo, the school transporter, to be questioned about Jayden's whereabouts, as the applicant in her missing persons report specifically stated that, I quote, "The last person to see my son is Mr. Kamalo." It is indeed on this premise that the house of Mr. Kamalo was searched. The child was not found. C. Back at Swazi Place around 2200 hours, the police questioned the night shift security guard, hereinafter referred to as Joe, who was on duty, whether he saw Jayden getting home during the day. Joe conveyed that the day shift guard, hereinafter referred to as Alex, finished work at 6 o'clock that evening, and that he, Joe, is willing to take them to Alex's residence, who resides less than a kilometer away. Alex, in the presence of the police and the applicant, stated that he was, in fact, the person who opened the gate for Jayden during the day. This he remembers specifically because he used the only remote which was in his possession. At that stage, the applicant interjected, accusing Alex of being a liar and not telling the truth. D. Alex, however, persisted that he opened and closed the gate for Jayden to enter the complex and proceeded to give a description of the clothing worn by Jayden. E. Further, Alex reported to the police that no report was made to him of a missing child. F. They then left to the residence of a child residing in the same vicinity that uses the same transport as Jayden. In the presence of the police, the applicant and family, they were informed that he was the one who opened the sliding door of the school bus to enable Jayden to alight from the vehicle. This child saw Jayden enter Swazi Place. G. They drove back to Swazi Place in convoy. They started searching for Jayden around the complex without success. Around midnight, the officers informed them that they did what they could and that the allocated investigating officer will be in contact. The SAPS left the applicant and family at the gate. The applicant informed that they wanted to assist in searching the vehicles that left the complex that morning. the applicant did not go back to Unit 13 but drove off with her family. H. Around 4 a.m. the applicant is dropped off by an unknown vehicle and she reports to the night shift guard that she is there to change clothes and go back to the police station. Joe inquired whether she will assist to search the vehicles before going to the police station, and applicant agrees. Between 5 and 5:30 the applicant exits the complex, stating that her bolt is waiting for her and that she is rushing to the police station. The security officer specifically records as per the OB entry that applicant did not change her clothes. Neither did she assist in searching any of the vehicles and simply walked off as no bolt was waiting for her outside the complex. Around 6 o'clock that morning, a tenant who was taking her child downstairs to the school transport informed the security that there's something lying on the stairs resembling a body and that he, referring to the security officer, should go and investigate. J, another resident who left before 5:30 a.m. reported that when he left for work, there was no body lying on the staircase. The body of the child felt cold to the touch and was not moving. The body was found next to the staircase pillar where it was slightly dark and moved by the security to an area where there was visibility. L, the body of Jayden was found 8 to 10 meters from flat number 13. M, around 8:30 that morning, when the police observed the body of Jayden, he had a small cut to the forehead, bruising to the neck, arms and right leg with blood on the lips. N, the body was removed at the scene and was handed over to Captain Hoffman, who took charge of the scene. O, crime scene role players were called in, including the photographer and dog handler, who made statements to this effect. The dog used on the day in question was Ace with service number B7003. In the first bedroom, the dog was released and he reacted positively for human blood next to a pillow, white in color. The pillow, which appears to be without a pillowcase, was collected and sealed inside a forensic bag. In the second bedroom, there was no reaction by the dog. P, the photographer, in the course of his duty, photographed a school bag in front of a wardrobe along with a school jacket which hung over the rail inside the wardrobe and school shoes at the bottom. Q, no samples was taken from the blood found on the mattress. Legal framework and considerations. The basic purpose of bail is indeed to strike a balance on the one hand between the interests of society in that an accused should stand her trial, and on the other hand the liberty of an accused who, pending the outcome of her trial, is presumed to be innocent. Bail is not anticipatory punishment. In determining whether the interest of justice permits the release of a particular applicant on bail, the courts are directed by the provisions of Section 60, bracket 4 to 9 of the Criminal Procedure Act. Section 60, bracket 4 provides that the interest of justice does not permit the release from detention an accused where one or more of the following grounds are established. A, where there's a likelihood that the accused, if she were to be released on bail, will endanger the safety of the public or any particular person or will commit a Schedule 1 offense. B, where there's a likelihood that the accused, if she were to release on bail, will attempt to evade her trial. C, where there's a likelihood that the accused, if she were to release on bail, will attempt to influence or intimidate witnesses or conceal or destroy evidence. D, where there's a likelihood that the accused, if she were to be released on bail, will undermine or jeopardize the objectives of the proper functioning of the criminal justice system, including the bail system. E, where in exceptional circumstances there is a likelihood that the release of the accused will disturb the public order or undermine the public peace or security. In S versus Matabula, it was stated that, but a state's case, supposed in advance to be frail, may nevertheless sustain proof beyond a reasonable doubt when put to the test. In order successfully to challenge the merits of such a case in bail proceedings, an applicant needs to go further. He must prove on a balance of probability that he will be acquitted of the charge. With reference to the cases of S versus Botha 2001 bracket 2 SACR page 222 Supreme Court of Appeal decision at 230H 232C, as well as S versus Viljoen 2002 bracket 2 SACR 550 Supreme Court of Appeal decision at page 556C. In S versus Botha and under 2001 bracket 1 SACR 222 Supreme Court of Appeal decision, it was stated that there is no doubt that strength or weakness must be given similar consideration in determining where the interests of justice lie for the purpose of section 6011B. When the state has either failed to make a case or has relied on one which is so lacking in detail or persuasion that a court hearing a bail application cannot express even a prima facie view as to its strength or weakness, the accused must receive the benefit of the doubt. The case presented to the court of first instance falls into the second, does not fall into the second category. The approach to the ground in section 60 bracket 4E read with section 60 bracket 8 capital A has been settled in Dlamini 1999 SACC Constitutional Court decision, where Kriegler J held as follows at paragraph 57, that it is important to note that subsection 4E expressly postulates that it is to come into play only in exceptional circumstances. This is a clear pointer that this unusual category of factors is to be taken into account only in those rare cases where it is really justified. What is more, subsection 4E also expressly stipulates that a finding of such circumstances has to be established on a preponderance of probability. Lastly, once the existence of such circumstances has been established, paragraph E must still be weighed against the considerations enumerated in subsection 9 before a decision to refuse bail can be taken. Having regard to these jurisdictional prerequisites, the field of application of subsections 4E and 8 capital A will be extremely limited. Judicial officers will therefore rely on this ground with great circumspection, in the knowledge that the Constitution protects the liberty interests of all. Further, that this court should not lose sight of the very high yardstick of section 60 bracket 4E read with sections 60 bracket 8 capital A and the salutary warning expressed in S versus Kittercut 1999 bracket 1 SACR page 100 Constitutional Court decision at paragraph 104, where the court said, no more than expression in statutory form of what amounts to lynch law. It is true to say that it is the duty of courts of law to ensure the maintenance of law, order, and justice, and so prevent the greatest of all evils, a criminal justice system so weak and facilitating that people feel the need to avoid the courts and take the law into their own hands. Despite this, courts have a greater obligation to society at large. They must jealously guard the rule of law. That is the lesson of this century. Legal arguments. The defense argues that the merits of the charges leveled plays a very limited role until such time when the guilt of the applicant has been determined by a competent court. The defense reminds this court that the presumption of innocence at this stage still operates in the favor of the applicant. The defense draws the attention of this court to a number of flaws and contradictions in the state's case indicative of the weak case against the applicant as argued. 1. The different descriptions of clothing worn by the deceased on the day in question. 2. There is no evidence presented that blood was found on the school clothes worn by Jayden on that day. 3. No murder weapon was recovered. 4. The applicant maintains that the exhibits recovered were not present in the flat on 14 May when hordes of people had access to the flat. Neither was any of these exhibits pointed out to her. 5. The exhibits seized 2 days later on 16 May were not present in the flat. 6. Third parties had keys to Unit 13. Even unknown parties had access to the flat. Anyone, therefore, could have placed those exhibits in the flat. 7. No eyewitness can confirm that Jayden was in the company of applicant after being dropped off, or that she was the last person being seen with him alive. 8. Sniffer dogs present at Swazi Place proceeded to another unit on suspicion, but that the police did nothing. It is possible that the pillow was recovered from that unit where the sniffer dog picked up the scent of bodily fluids, referring to sperm, which was said in passing to the applicant. 9. Applicant, upon her arrest, was informed that the time of death was between 4 and 5 a.m. Applicant produced evidence that she arrived at Unit 13 at 15:22. 10. Various tenants use the same staircase and no one observed a body. The assumption can therefore be drawn that someone placed the body there after the applicant has already left. The defense goes on to argue in conclusion that someone has gone to great lengths to implicate the applicant in this case and defeat the ends of justice. The defense submits that the public outcry in this case, which existed at its inception, no longer exists. The defense states that the applicant can still be in custody for a lengthy period of time pending the finalization of this trial, and therefore, in conclusion, argued that the absence of the applicant having attempted to flee this court leaves this court with no option but to conclude that applicant is a suitable candidate to be released on bail. The state, in its closing arguments, sets up a factual matrix which, prima facie, as argued, points to the applicant as the prima facie cause of Jayden's death. The state argues that the applicant has done so by going onto an elaborate scheme to evade justice. As follows. 1. Applicant reported Jayden missing while knowing that the child was inside Unit 13, harmed. 2. Applicant pointed the transport driver as the last person to be with the child, causing him Apologies, we had an interruption with the electricity. Kindly reboot and let me know when we're ready to proceed. Court adjourns for a few minutes.
Of course.
Right.
Balekile. Angazibuzela uphathi.
Okay, wait a little bit. Okay, we should let me listen to you. Then I'll give this a tell you.
I mean, you have the phone to I know it's strong.
Banamanga.
Okay.
The next sentence.
Lona ulamuntu uthenga izinto le-doctors. Leli lika Yalalela.
Thank you. Thank you. On the assumption, the court places on record that we just had a short power outage. The court, however, resumes at paragraph 13, on page 13 of her judgment. The state, in its closing arguments, set up the factual matrix which prima facie, as argued, points at the applicant as the prima facie cause of Jayden's death. The state argues that the applicant has done so by going onto an elaborate scheme to evade justice as follows. 1. The applicant reported Jayden missing while knowing that the child was inside Unit 13, armed. 2. Applicant pointed the transport driver as the last person to be with the child, causing him to be a suspect and his residence to be searched, trampling his dignity. 3. The applicant returned on the morning of 15 May around 4 o'clock, where she removed the body of the child and placed him by the staircase a few meters from the unit. 4. The state accepts that this is all based on circumstantial evidence, which can be defined as indirect evidence which suggests a fact in issue but does not prove it directly. It thus requires the trier of facts to draw an inference to connect the evidence to the facts in question. To this end, the court was referred to the two cardinal rules in the case of R versus Blom. The state, in arguing the strength of the state's case, places reliance on the following considerations. A, human behavior, like the conduct of the applicant. B, physical evidence, like the school bag, pillow, and blood found inside the unit. C, indirect evidence of witnesses, such as the security guards on duty. D, the state reminds this court that it is the trier of fact, not speculation or conjecture, and that evidence under oath can only be vitiated by evidence under oath. E, the state argues that the applicant is a dishonest person, and her attempts to explain crucial oversights, like the omission in her statement, Exhibit AA, that she returned to Swazi Place around 4 a.m. that morning, was both dubious and disingenuous. The state argued that because applicant was not aware of what evidence the investigating officer was going to tender, did she not prepare, and was blindsided by the detail of the recording of the happenings by the night security on duty in the OB. State argues that applicant intentionally omitted the time she returned to the flat that morning because she did not want it to play on the mind of the court that she returned to the flat, placed the body of the child outside in his underwear, because that was her trying to create distance between her presence and the discovery of the body. And even if the time as alluded to by the applicant is accepted, it does not change the fact that the body of the child was discovered after she left the complex and not before. If the state argues that applicant does not have a stable address as the current owner where her biological father resides, did not commit to a lease agreement in writing, and can therefore evict them on a whim. Further, applicant can continue to work remotely from anywhere. Her continued employment is not attached to an address or conditions, thus being a flight risk is a possibility. G, the fact that applicant faces life imprisonment is a likelihood if convicted, making her a flight risk. H, the applicant endangering the safety of the public or disturbing the public order or undermining public peace is a likelihood. The state argues that the court should be mindful that the applicant did not give her mother's address here in Florida because she knows the community's anger and outrage if she dares linger within the borders of this province. The state submits that the online petition after the applicant's arrest reflects societal anger. It's as if the applicant was riding on the societal sympathy at the onset. However, now that the proverbial horse feels pain, it bucks and the rider is unceremoniously dismounted. State argues that applicant has incurred the ire of society. It is exactly because of this that applicant, and not the investigating officer as argued by defense, gave the address in KZN out of fear of reprisal at the hands of the very community who supported her and even drafted a petition demanding justice for Jayden. Further, the applicant is at pains to explain how she will navigate traveling from Durban on a daily basis, given the continuous roles as set in the High Court, which will be the forum to adjudicate the trial. All the aforementioned will incentivize applicant to evade trial as argued by the state. The state therefore submits that the applicant has failed to show on a balance of probabilities that the interest of justice warrants her release on bail, and therefore bail should be refused for the applicant. Evaluation. This court is mindful with reference to the case of State versus Atchison 1991, bracket 2 SA, page 805, Namibian decision, where Muhammad J. said the following: an accused person cannot be kept in detention pending his trial as a fourth anticipatory punishment. The presumption of law is that he is innocent until his guilt has been established in court. The court will therefore ordinarily grant bail to an accused unless this is likely to prejudice the ends of justice. The court equally is mindful of the case of Ewan, where Stein J. remarked as follows: in regard to bail application, it is increasingly found that prosecutors and even magistrates regard themselves simply as the rubber stamps for the attitude of the police as to whether bail should be granted or not. The dangers of such a departure are clearly apparent. A strict independent adjudication of the facts of each case, which should include a careful evaluation of an accused's circumstances, the seriousness of the offence and the interest of the community, should be undertaken by the presiding officer in each case. The investigating officer's attitude is obviously a relevant consideration, but not the only, and certainly not the most important factor for a court to consider as to whether an accused ought to be granted bail. The question that begs answer is, what is the objective evidence presented of the likelihood of the eventualities envisaged in section 60, bracket 4 to 9, Deadworth 8, capital A, occurring? In addressing the presumption of innocence, this court is mindful of the case of Conradi versus S, where the court referred to paragraph 14 in the Dlamini case 1999, where the Constitutional Court had decided that the presumption of innocence is indeed a peculiarly trial-related right, as evidenced by its entrenchment as one of the fair trial rights listed in section 35, bracket 3 of the Constitution. I therefore agree with Stein J's stated view that the presumption of innocence does not play a determining role in bail applications. A court seized of a bail application fulfills a very different function from a trial court. Its role is not to determine the guilt or innocence of the accused person. The bail court's concern with the interest of justice in the sense of weighing in the balance the liberty interest of the accused and the interest of society in denying the accused bail will, however, in most cases entail that it will have to weigh as best it can the strengths or weaknesses of the state's case against the applicant for bail. The presumption of innocence, therefore, is but one of the factors that must be considered together with the strength of the state's case. The state in my view, in presenting persuasive arguments to gainsay that of the defense, correctly asserts that the behavior of the applicant on the day that Jayden allegedly goes missing raises more questions than answers, in as much as considered normal behavior can vary significantly. It still begs the question why, if Jayden was dropped off by the school transport around 3 o'clock, why was the alarm bells not sounded sooner? The applicant was seen by the day shift security leaving the premises smoking around 5:30. Any parent at that stage would be frantic, to put it mildly. Why then is a missing persons report only lodged between 7 o'clock and 8 o'clock that evening? And why is the security only informed of Jayden's disappearance around 8:30? The state correctly, in my view, argues that there is no evidence to suggest that Jayden knew other people in the complex, or as the habit will visit or play with other children in the complex, bearing in mind that they had lived there only for plus minus 2.5 months. This court has no challenge in accepting that Jayden was, as a fact, dropped off by the school transport that afternoon in question. Upon returning from the police station after the missing persons report was filed, why will applicant not return to a flat given the chance that the child could have returned home and finding no one there? Instead, she goes to her mother's place as she was devastated and emotional. This court deems it no coincidence that applicant omitted from her statement that she went back to the unit on the morning of 14 May to freshen up. The OB entry clearly stated that the applicant did not change her clothes and there was no bolt waiting outside as she simply walked away. At that stage, Jayden was still not found. Why is there such a persistence almost on the part of applicant to remain, not to remain at the flat, in the likelihood of Jayden returning, if not to create distance between herself and the lifeless body of her child? Why else was applicant in a hurry that morning according to the security guard on duty? Honesty in bail proceedings is of utmost importance, as the lack thereof may undermine the integrity of the bail system and is punishable by law. Courts are therefore more likely to deny bail if it believes that the applicant is not truthful and may be a flight risk or influence witnesses or interfere with investigations. The following ambiguous statements or factors were highlighted before this court with the sole purpose of creating doubt in the mind of the court and deflecting from the truth. 1. The fact that the investigating officer felt that applicant was not safe in the province, creating the impression that DECO came up with the address in Durban as an alternative. 2. Creating the impression that if the court grants bail and the applicant resides with her mother, that applicant can do so at her own risk, thus assuming the risk of being badly injured or worse, still killed. 3. That the applicant has an alibi. 4. The different descriptions of clothing, implying that the witnesses may be fabricating a version, whereas applicant maintains that Jayden did not wear the red school jacket on the day in question, but at least 2 people stated otherwise. 5. The fact that applicant approached the day shift guard at 5 o'clock that evening and he informed her that he did not see the child being dropped off by any transport, when in truth she never reported Jayden missing. That the guard made an entry of this report in the OB and she supplied him with her telephone number, informing him that she is walking to the shop to check for Jayden. Later, applicant's mother sent Mpo to take applicant to the police station, and again the contact numbers of Mpo and Quen was recorded in the OB. When applicant, however, wanted to take a photo of the OB where the entry was made, it has mysteriously disappeared. 6. There was a suggestion that there are missing entries indicative of either tampering or destroying evidence. However, when the original OB was brought to court, this argument was abandoned. 7. Applicant will further say that it was in fact the night guard who saw Jayden in the vicinity of the complex only wearing a vest and shorts. This, despite the assertion that it, however, creates the impression that Jayden was outside Unit 13 at this stage. 8. Exhibit L, showing the bolt trip from Hull Street at 5:12 and applicant alighting at 5:22, does not succeed in creating doubt in the state's case. 9. Applicant was informed that the time of death was between 4 and 5 a.m. This is not confirmed in the post-mortem or anywhere else. 10. The school book inside the school bag contains the name of Jayden and his classwork for the day of 13 May 2025. However, applicant denies seeing a worksheet which undoubtedly states the name of Jayden-Lee Meek. 11. Applicant's instructions is that no one saw the pillow taken from her unit and placed in a forensic bag. 12. Applicant in the same vein instructs that Jayden suffered with nosebleeds, which blood could have been there for the past 6 months. 13. Applicant instructs that all the pillows in her unit have pillowcases, yet the pillow that was seized, noteworthy, had no pillowcase. 14. Applicant instructs that a certain social media personality made the statement that she made a video of the sniffer dog picking up a strong scent leading to the top floor of the complex, but that the police failed to follow through, thus accusing the police of failing in their duties. 15. Applicant instructs that the body was moved at least twice, and then the night guard placed the child's body closest to applicant's unit, it being 2 meters from a front door. 16. Applicant denies that Kamala's property was searched in her presence. 17. Applicant instructs that the red school jacket as seen in the photo was a spare school uniform jacket. 18. Applicant's instruction is that the underwear in the bathtub has been there from 5 days prior. This is peculiar given the evidence of applicant that the underwear was blood soaked. 19. Applicant's instruction is that the pillow was found inside a different flat which was opened by the landlord after the dog picked up a strong scent. And that something like semen was found, but again the police refused to do their job. 21. Applicant observed strangulation marks on Jayden's neck. However, this is refuted by the findings in the post-mortem report. 22. Applicant instructs that the OB produced in court was not the book she wrote her details in, and that the OB in court was reconstructed. 23. If applicant knew she was a suspect, why would she not have disposed of evidence indicative of the fact that the evidence was planted and that applicant is being falsely implicated? This court is mindful, as was stated by Davis J., that justice cannot be served by sacrificing constitutional rights on the altar of outrage. However, objectively, Jayden had no defensive injuries, and the post-mortem informs that Jayden had a 6 centimeter by 5 centimeter deep skull bruise, indicative of force applied to the left temporo-occipital skull. The reddish abrasions indicates the freshness of the wounds, and there was no evidence to suggest sexual assault, as the applicant from time to time wanted this court to believe, hence alluding to the alleged blood-soaked underwear, which proved to be untrue from the photographs observed, misleading the court as the consequence that an atmosphere and environment is created where it is difficult to trust the information presented. The applicant has shown that she has the ability to defeat or obstruct the administration of justice by causing other persons to be suspected and attempting to defeat or obstruct the cause of justice by placing Jayden's body outside her unit or stairs to create the conclusion that the child was harmed elsewhere. These inferences are consistent with the proved facts, and it excludes every other reasonable inference except for the one sought to be drawn. If applicant has the ability to deceive without hesitation, then surely the applicant has the ability to influence witnesses, especially her family. She will likewise also have the ability to undermine or jeopardize the objectives of the proper functioning of the criminal justice system. Her release will have the likelihood of undermining the public peace if the online petition is anything to go by. All the aforementioned in turn can incentivize applicant to evade her trial, especially in the absence of a fixed address within the borders of this province. In the case of S versus Jonas, it was held that the applicant would succeed if she is able to show by adducing acceptable evidence that the state's case against her is non-existent or subject to serious doubt. This is not the case in the present matter. The applicant failed to satisfy this court that she discharged the onus in proving on a balance of probabilities that the interest of justice permits a release from detention in terms of section 60, bracket 11b of the Act. Bail is accordingly refused for the applicant.
As the copy is yours.
Thank you. That is the ruling of this court. The matter is transferred back to Court J immediately for further dealings. Court adjourns.